Parties, 19. Walt Disney Parks and Resorts, U.S. Inc. is a Florida corporation with its principal place of business in Orange County, Florida. Disney owns and operates Walt Disney World in Central Florida. Guests from around the world visit to enjoy a Disney vacation where family members of all ages laugh, play, and learn together. 20. Defendant Ronald D. DeSantis is the governor of Florida. Governor DeSantis called on the legislature to pass bills to punish Disney for its speech. One bill dissolving the Reedy Creek Improvement District, RCID, or the district. The other installing a governor-selected oversight board. He signed into law Senate Bill 4C, 2022, and House Bill 9B, 2023, and appointed the members of the newly constituted Central Florida Tourism Oversight District, CFTOD, or the District Board, Disney's local regulator. And then it references Florida Constitution Article 4, and you can look at that if you want. He is sued in his official capacity. 21. Defendant Meredith Ivey is the acting secretary of the Florida Department of Economic Opportunity. Acting Secretary Ivey serves as the head of the Florida Department of Economic Opportunity, Florida Statute 20.62. And you can look at that. The Florida Department of Economic Opportunity is authorized by statute to maintain the official list of special districts, which includes all special districts in Florida. And there's a reference to another Florida statute there. The Secretary of the Florida Department of Economic Opportunity is appointed by the governor, reports to the governor, and serves at the pleasure of the governor. Florida statute, again. She is sued in her official capacity. And so it goes on to list each board member in their official capacity. And so I won't read all of that because it's kind of long-winded, but 22 would be Defendant Martin Garcia. He's the chair of the Central Florida Tourism Oversight District Board. He was appointed by the governor and is sued in his official capacity. 23 was Michael Sasso. 24, Brian Ongst Jr. 25, Ron Perry. 26, Bridget Ziegler. 27, John Klass, and he's the district administrator, not a board member. Okay, so I'm just going to skip that part, but the district administrator is in charge of the day-to-day operations of the district, subject to the Board of Supervisors' direction and policy decisions. So they're all sued in their official capacity. Jurisdiction and venue. The court has subject matter jurisdiction under 28 U.S.C. 1331 and 1343 because this action arises under the United States Constitution and federal law. This court has authority to grant relief under the Declaratory Judgment Act. I won't read the numbers. 30. In addition, this court has authority to issue injunctive relief under the All Writs Act. And there's a reference number there too. 31. This court's jurisdiction is properly exercised over defendants in their official capacities as Disney is seeking declaratory and injunctive relief only. 32. This court has personal jurisdiction over defendants, and venue is proper in this district pursuant to 28 U.S.C. 1391 because a substantial part of the events giving rise to this claim occurred in this district. 33. There is an actual and justiciable controversy between Disney and defendants of sufficient immediacy and concreteness relating to the parties' legal rights and duties to warrant relief under these laws. Because Senate Bill 4C, House Bill 9B, CFTOD's April 26, 2023 legislative findings and declaration that Disney's contracts are void and unenforceable, the legislative declaration, constitute a present and continuing infringement of Disney's constitutional rights. Factual background. A. The Reedy Creek Improvement District has benefited Florida and its residents for decades. 34. In 1963, Walt Disney looked down on acres of undeveloped Central Florida land from an airplane seat and saw potential. Disney quickly acquired title or options for over 27,000 acres of land comprising roughly 43 square miles in Central Florida. 35. In 1966, the state created the Reedy Creek Drainage District, which allowed Disney, the largest landowner, to begin the effort of draining and reclaiming land so that the actual site construction would be possible. The following year, the Florida legislature expanded the scope of the district's authority, establishing the Reedy Creek Improvement District. See Florida Laws, Chapter 67 through 764, Reedy Creek Enabling Act. 36. In the Reedy Creek Enabling Act, the legislature recognized that the economic progress and well-being of the people of Florida depend in large measure upon the many visitors and new residents who come to Florida. Reedy Creek Enabling Act at 4, and to that end, the legislature granted RCID powers, functions, and authorities necessary to foster a recreation-oriented community that would enable enterprises to undertake a broad and flexible program of experimentation and development. ID at 5. RCID was tasked with providing for the reclamation, drainage, and irrigation of land, water and sewer systems, and waste collection and disposal facilities, public transportation and public utilities, and streets, roads, and bridges. The legislature determined that the purposes of the act could not be realized except through a special taxing district having these powers. 37. In 1968, the state of Florida challenged RCID's power to issue drainage bonds, and it references a previous, lawsuit from 1968. The state argued that because Disney was the largest landowner in the Reedy Creek Improvement District, the water control improvements funded by the bonds would impermissibly put public funds to a private purpose. The Florida Supreme Court rejected the challenge, finding the RCID served a public purpose, in particular that the purpose of RCID was essentially and primarily directed toward encouraging and developing tourism and recreation for the benefit of the citizens of the state and visitors to the state generally. 38. The Florida Supreme Court also confirmed that the legislature had properly established RCID, explaining that the legislature, in the exercise of its plenary authority, may create a special improvement district encompassing more than one county and possessing multi-purpose powers essential to the realization of a valid public purpose. The court further emphasized that while RCID's powers over land use and economic development were broad, they were not commensurate in scope with those characteristics of a local municipal government and were not a mere subterfuge to avoid the creation of a municipality. 39. In the decades that follow, RCID has played a critical role in providing vital services for tourism in Central Florida. RCID enforces building codes, provides emergency services, and offers utilities, subject to the oversight of state and federal regulators. Under state law, special district board meetings are open to the public, and districts provide reasonable notice and produce minutes of each meeting. These records are open for public inspection. In a 2004 report, Florida's Office of Program Policy Analysis and Government Accountability concluded that RCID was meeting the public purpose expressed in its special act. 40. Today, the area formerly governed by RCID, now governed by CFTOD, encompasses approximately 25,000 acres of land and covers portions of Orange and Osceola counties. The district employs hundreds of employees responsible for stewarding the land, consistent with environmental regulations and public safety. The district has built 134 miles of roadways and 67 miles of waterways. It has managed 60,000 tons of waste. It recycles 30 tons of aluminum, paper, steel cans, cardboard, and plastic containers every year. It uses thousands of vendors, suppliers, and contractors to provide a high level of public services for visitors. 41. Disney is the primary landowner in the district, and as a result, it is its largest taxpayer. For the 2022 fiscal year, Disney-owned land constituted 87.7% of the total taxable assessed value within the district. 42. Like many other special districts in Florida, RCID board members were, until recently, elected on the basis of property ownership within the district. As RCID's largest landowner and taxpayer, Disney naturally had substantial input into RCID's acquisition of property, development of transportation facilities, operation of public utilities, and insurance of revenue bonds, among other things. Disney, since the beginning, was the primary contributor to the unprecedented success of RCID's development objectives. B. Over a multi-year process, Disney and the district complete the Comprehensive Plan 2032. 43. Under Florida's Community Planning Act, a special improvement district is required to adopt a comprehensive plan that guides future growth and development. Comprehensive plans include elements addressing affordable housing, transportation, infrastructure, conservation, recreation and open space, intergovernmental coordination, and capital improvements. Florida law also requires that special districts review their comprehensive plan every 7 years to determine whether amendments are necessary. 44. The current comprehensive plan is the RCID Comprehensive Plan 2032. Comprehensive Plan. RCID and Disney began collaborating years ago, in 2018, to settle on the amendments captured in the Comprehensive Plan. Among other things, the Comprehensive Plan details maximum development limits down to the square foot through 2032 for hotels, office space, retail, and restaurants and theme parks. 45. On May 25th, 2022, RCID held a public hearing on the Comprehensive Plan. At that hearing, RCID's planning and engineering team advised that the contemplated amendments would bring RCID's comprehensive plan up to 2032. After discussing questions from the board and soliciting public comments, there were none, the board unanimously approved the comprehensive plan. The city councils of Bay Lake and Lake Buena Vista had each unanimously approved the comprehensive plan the day before. 46. Shortly thereafter, on June 2, 2022, RCID submitted the comprehensive plan to the state's Department of Economic Opportunity for review. By letter dated July 15, 2022, the department confirmed that it had reviewed the amendment in accordance with the state coordinated review process set forth in Section 163.31842 and 4 Florida statutes and had determined that the adopted amendment meets the requirements of Chapter 163, Part 2, FS for compliance. The department thereby determined that among the many other legal requirements if satisfied, the plan properly set forth the principles, guidelines, and strategies for the orderly and balanced future economic, social, physical, environmental, and fiscal development of the area that reflects community commitments to implement the plan and its elements. 47. By statute, an affected person can file a challenge to a plan amendment. A petition challenging a comprehensive plan amendment must be filed within 30 days after the plan amendment is adopted. No petition was filed, and the comprehensive plan became effective on July 15, 2022. C. Disney publicly comments on House Bill 1557. 48. The Florida legislature passed the Parental Rights and Education Act, House Bill 1557, in March 2022. The public discussion before and after the bill's passage was robust, not only in Florida, but across the country. Commentary came from all corners, including leaders of global corporations and editorial boards of major newspapers. And that's in quotes. 50. As a Florida corporation and taxpayer with tens of thousands of Florida-based as a Florida corporation and taxpayer with tens of thousands of Florida-based employees, Disney took an interest in the bill. On March 9th, the then CEO of Disney's parent company, the Walt Disney Company, called Governor DeSantis personally to express the company's concern. 51. Governor DeSantis recounts thinking that it was a mistake, in quotes, it was a mistake for Disney to get involved, end quote, and telling Disney's then CEO, quote, "You shouldn't get involved. It's not going to work out well for you," end quote. 52. On March 10th, Governor DeSantis' campaign sent an email accusing, quote, "woke Disney," end quote, of, quote, "echoing Democrat propaganda," end quote. 53. Walt Disney World issued the following statement shortly thereafter. "To all who come to this happy place, welcome. Disney Parks, Experiences, and Products is committed to creating experiences that support family values for every family and will not stand for discrimination in any form. We oppose any legislation that infringes on basic human rights and stand in solidarity and support our LGBTQIA+ cast, crew, and Imagineers and fans who make their voices heard today and every day. 54. Governor Ron DeSantis signed House Bill 1557 into law on March 28th. That day, the Walt Disney Company issued a statement expressing its views that the legislation never should have been signed into law, that its goal as a company is for this law to be repealed by the legislature or struck down in the courts. And the Walt Disney Company remains committed to supporting the national and state organizations working to achieve that. 55. On March 29th, Governor DeSantis said he thought the Walt Disney Company's March 28th statement had, quote, crossed the line and pledged to, quote, make sure we're fighting back in response to Disney's protected speech. 56.